Namaskar, hello and a very warm welcome viewers. You're watching Bills and Insight, your one-stop destination for views, news and analysis of proposed legislations of India that have far-reaching implications and impact your life. I'm your host Kruti Mishra, and today the spotlight is on an act that concerns half of the population of this country. Yes, you guessed it right. You're talking about an act that concerns women. The Medical Termination of Pregnancy Amendment Act of 2021 that amends the Medical Termination of Pregnancy Act of 1971. Before the analysis, let's take a look at the highlights of the Amendment Act. It enhances the upper gestation limit from 20 to 24 weeks for special categories of women. Special category includes survivors of rape, victims of incest and other vulnerable women like differently abled women and minors. It allows abortion to be done on the advice of one doctor up to 20 weeks and two doctors in the case of certain categories of women between 20 to 24 weeks. Focus on privacy, as a registered medical practitioner may only reveal the details of a woman whose pregnancy has been terminated to a person authorized by law only. So why did we need this amendment? Recently, several petitions were received by the courts seeking permission for aborting pregnancies at a gestational age beyond the permissible limit to make abortion safer and in tune with the changing times. Thousands of deaths are reported from unsafe abortions due to lack of abortion providers, lack of knowledge about the legality of abortion and availability of safe services, compounded by social stigma surrounding abortion. Stigma and attitude towards women, particularly young unmarried women seeking abortion, leads to unsafe abortions. Some providers refuse to perform abortions on young women or demand that they bring their parents to the health center. So Government of India brought these amendments to increase the ambit and access of women to safe abortion services and to ensure dignity, autonomy, confidentiality and justice for women who need to terminate their pregnancies. So what are the changes? The Act of 1971 applies to married women. The amendments allow unmarried women to medically terminate pregnancies, citing contraceptive failure as a reason for seeking an abortion. Under the law, termination of pregnancy from 12 to 20 weeks is with the advice of two doctors. The amendments mandate advice of one doctor in the same period. Under the law, abortion up to 20 to 24 weeks is not allowed. The amendments paved way for abortion with advice of two doctors. Under the law, abortion is not allowed in more than 24 weeks. While the amendments provide for it with the permission of a medical board in case of substantial fetal abnormality. And to discuss the Amendment Act threadbare, we have very eminent guests on the panel today. Joining us on the program, Dr. Ami Yagnik. She's a member of the Upper House of Parliament. She's also a lawyer and a prominent voice on rights of women. She's joining us through virtual platform from Gujarat. And in the studio, we have with us Dr. Sunita Malik, Professor of Gynecology, Safdarjung Hospital. Welcome to Sansad TV, both of you, and thank you so much for joining us. And also in the studio, we have with us a very vibrant audience, students and young professionals. I welcome you all to Sansad TV. And before the analysis, let's take a look at how our parliamentarians debated this issue.
This bill is an endeavor to strike a balance. Number one, between increasing the upper gestational limit for termination of pregnancy, and on the other hand, ensuring safe, accessible and affordable abortion services.
ऐसे माताएं, ऐसी बहनें जो गर्भवती हो जाया करती थीं, अगर उनको गर्भ से निजात पाना होता था मानवर, उनको अच्छे डॉक्टर नहीं मिलते थे, जिनके कारण वो गांव के नीम हकीमों से और जो गैर कानूनी डॉक्टर से हैं उनसे गर्भपात कराते थे, जिसका परिणाम यह आता था कि वो उनकी शारीरिक स्थिति खराब हो जाती थी.
So terminating a pregnancy for a woman to make that decision is mentally, emotionally and a very physically impacting decision that she takes in her life. And for her, who is in advanced stage of pregnancy and a stage where she knows there is life inside her womb, for her to take that decision is a difficult one indeed.
सोसाइटल नॉर्म्स जिस प्रकार से चेंज हो रहे हैं और उसमें सिंगल वुमेन जो है उसका भी अपना एक राइट है, विडोज का भी अपना एक राइट है, उसमें जो ये कमर्शियल सेक्स वर्कर्स हैं उनके भी राइट्स हैं। इन सारी बातों का मद्देनजर रखते हुए और ये जो बिल इस स्टेज में आया, जैसा मैंने शुरू में कहा था कि शायद हर पॉसिबल जो स्टेक होल्डर हो सकता है उस स्टेक होल्डर से, उस मंत्रालय से, विशेषकर वुमेन एंड चाइल्ड मिनिस्ट्री, दूसरे, इन सबसे बहुत लंबे समय तक इसके बारे में चर्चा हुई है।
So what will this legislation mean for India? Dr. Yagnik, let me begin the program with you. Across the world, countries set varying conditions and time limits for allowing abortions based on fetal health and risk to the pregnant woman. The access to abortion facilities in India was limited due to legislative barriers. Take us through the importance of this legislation.
First of all, thank you for giving me this opportunity. It's a great legislation and needed at this time of the hour. And we may not say that we have been little behind as far as this legislation is concerned, because we had it way back as in 1971. It was considered progressive at that time because we provided for legislative measures in the act, the time limit and who should perform the abortions, and how a woman could get this kind of facility, or we can say healthcare access. So it was in 1971 we had the Parent Act, and thereafter, after 50 years, we had this amendment in the bill. And the amendment comes at a time when we find lots and lots of problems women face as far as childbearing is concerned, as far as abortions are concerned, as far as well-being of a woman during these pregnancy times are concerned. And then we have a number of fetal kind of abnormalities that come to the fore when the woman goes to the doctor. So in this particular time frame, when we have such an legislation which is amending the parent bill, it was definitely a welcome step. And the highlights are that when earlier in the Parent Act, it was that the gestational limit was only up to, say, 20 weeks, and she could go for abortion. That was now raised by this amending bill to 24 weeks. Thereafter, there was also the number of doctors. You know, earlier there were 2 doctors that were prescribed in the legislation or provided in the legislation. Now it was narrowed down to 1. The third most important, which you mentioned in your introduction also, that there were lots of writ petitions in the various high courts and Supreme Court, which said that the woman who had approached the court, whether by way of some kind of maybe a fetal abnormality, or maybe because she was a rape victim, or maybe she was having some kind of other issues, and she had knocked the doors of the court so that she could go for an abortion and see that she does not carry the fetus anymore beyond 24 weeks. Because it was not provided in the earlier legislation, she had to go to the court by way of a writ petition. That is what a petition is called. And she would request the permission of the Honorable Court that she may be permitted to abort the fetus, and the doctors may perform this particular surgery pursuant to the order received from the court, because it was not provided in the law. Now, this particular writ petitions were so many in numbers in various high courts and the Supreme Court that it brought to the fore the ugly reality, I would say, of our society. So many rape victims, so many young girls having these kind of pregnancies, and they would like to go for an abortion. Many fetal abnormalities also, which was by way of observed in these judgments. And that is why this bill came. So beyond 24 weeks also, she could go for an abortion, and that could be performed by the doctors. That is provided in the present legislating amending bill. And that too, a caveat is put that she has to take the permission of a medical board. That is where I think that was a little too strong to be put into the act, that why should she go to a medical board? Of course, the medical board would be manned by 4 specialists, a pediatrician and the gynecologist and the sonography person, specialist. But then whether she would be at particular point of time running from her, maybe whether she's in a rural setting or a urban setting, go to a medical board and go through the rigmarole of the procedures. And that is where I think I had a little objection that this should be considered or reconsidered by looking into the aspects which are bringing this medical board at the state level, which would, according to me, is a kind of a state intervention when a woman has a right to reproduction, where she has a right to reproductive rights. She also had the right to choose. So all these are issues were discussed or debated in the parliament, but the amending bill was passed. These are the highlights of the bill, and the main issue is that a woman is given this kind of choice to go to the doctors. The doctors also have been given some kind of a provision in the law that they should not disclose the name of the person who is coming to them. So there are lots of checks and balances in the amending bill. But ultimately, it narrows down to whether a woman who is passing through this emotional, traumatic phase needs to undergo these kind of procedural aspects, and whether will this impart, in the end, justice and dignity to the woman. That is the thrust of any law which is brought in the country. Whether you give that dignity to the person who is wanting to make use of the law. And when the state says that this is a law provided for every woman who is in this country, will that law in the end give dignity to the woman?
All right, so that's a very important point that you're raising, ma'am. Let me take that to Dr. Malik. Dr. Malik, we're talking about comprehensive health care for women. Now, of course, one has to ensure that all these standardized protocols and norms are in place. How will this Amendment Act ensure that women get access to comprehensive post-abortion care as well?
Yeah, that's very important. Thank you for inviting me over for this. We need to, ensure that it goes to the grassroots level. That's very important. And this act was required, this bill was required. This is the demand of the present generation. Earlier, we had to, ask for the husband's consent, and then now she can come on her own. And then she had to have the partner's name also. Like it used to be some illegal thing. Now it's all legalized. Only thing is how to disseminate this message. That's very important. Now we have better technology also, better scientific medicines also to do this medical termination of pregnancy. So it is now safer as far as the women are concerned for this beyond 20 weeks. That's very important.
All right, so we also need to disseminate this information.
Yeah, that's very important.
To remote and far-flung areas as well.
Exactly.
But talking about another legal point, Dr. Yagnik, we know that you've been fighting for decades, for years, for the cause of women. In Justice Puttaswamy versus the Union of India and others, the court recognized that constitutional right of women to make reproductive choices as a part of personal liberty under Article 21 of Indian Constitution, based on a robust jurisprudence on reproductive rights and the privacy of a woman. Can you help us decode that?
See, the Constitution of India has given us a plethora of rights and special rights to women and children. And because of those rights, the state also has an obligation to form laws or to enact laws that protect the rights of the women. And that is why India is the only country that has got specific and beneficial legislation for women and children. So, for example, a woman has a right to equality and equality before law. We also have an act that says she has a right to free legal aid. She can go to centers where legal aid is provided and she does not have to pay for that legal services. But coming to this judgment, yes, when the Honorable Court mentioned or said that, yes, the right to life, Article 21, also says that the woman has a right to choice. She has a right to a reproductive rights, and she can choose how she wants to go ahead with her reproductive rights. This has also settled in many other countries also, that she has the right to choose and the right to reproduction. But in India, as you have seen that just now we heard our colleague doctor saying that, yes, now she has the right to give the consent herself. Earlier, she had to take her husband. There's a partner provision also provided in the legislative bill that, okay, she can come with her partner. Earlier, it was only husband. So these are the issues where the woman was bogged down or is bogged down in our country by customs, by tradition, by the orthodoxy mindset, and also a patriarchal mindset. Let us not forget that in the country. And so when the Honorable Court in this particular judgment said that the right to life also includes that she has a right to choice and the right to reproductive rights, it is a very, very welcome and a progressive kind of observation. But it cannot be mandated. It has been observed by the Honorable Apex Court. It is for the state to put it by way of a law, because we have our constitution in two main parts, which is a fundamental rights for the citizens, and the other is directive principles of state policy. When the articles provide that there's a right for freedom, right to equality, women have this right to life, right to clean air, everything is included in the right to life, then the state's onus, it is on the state to formulate acts and laws. So that is what the Honorable Court meant. But then some part of it has crept in this particular amending legislation, where that consent is not required. The fetus time, the abortion timeline has been increased, but there have been checks and balances by way of medical boards. But where is the choice for the woman? Apart from fetal abnormality, apart from any complication, apart from thinking about what the child would be, whether the child would have a mental abnormality, whether the child would be able to be healthy, or whether the woman's well-being will be affected or not affected, these are the choices a woman has to make herself. And whether that choice is given to her, that is what the Honorable Court has mentioned, that the right to life includes this right of the woman to have her right on her reproductive right. So if a woman cannot take the decision herself about her own body, then what is the sense of this freedom, or what is the sense of this right to life? So this is what it meant. But I think we are now in the third decade of the 21st century.
Yes.
People are moving forward. The information technology and artificial intelligence is doing wonders, and it is moving so fast that, well, someday all these rights will become so fruitful, it would fructify, and women will be able to take the choices themselves, make the choices themselves.
Absolutely. So women will be able to make the choices themselves. But talking about another aspect, ma'am, I was reading a report which says that in developing nations, $553 million that's lost because of treating complications related to unsafe abortions. I'd just like to understand that what are the complications, and also there's a massive economic and social loss.
Definitely, the complications could be due to the procedure itself, what they are going illegally. It could be incomplete abortion, and she keeps on bleeding and anemia and may also die also. Maybe some perforation in the uterus, and then it goes into the peritoneum, the whole abdomen becomes full of blood, rupture of the uterus. Or it could be post-abortion care if she is not, no antibiotics, nothing, and no aseptic precautions are taken, then sepsis can occur, and she may have septic abortion, and that can also have its own sequelae and complications of that. Patient may have, the woman may have. So it has a very complications, and even if right now also, even if this law is there, but not many women know about it. That's the more problem. Still, they are going to some illegal person and getting it done, and still, although we have medical methods also, still it's being done surgically by quacks and things. So that information has to be given. So still, we are getting complicated cases in our hospital after all this cases. So still, lots to be done.
All right. So before we take the questions from our audience, Dr. Yagne, that is the concern that Dr. Malik is flagging, that still there are quacks and still the abortion is done in a clandestine manner. How do we ensure that this information reaches far and wide?
Well, I had shown the National Family Health Survey, where it showed that almost about 80% doctors are not present in these primary healthcare centers or community healthcare centers, which are the first point of time where a woman can get access to any kind of medical treatment at the rural or semi-rural areas. I also showed that in the last 2-3 years, what was the rate of abortions that was conducted, and they were done by midwives and quacks. My colleague doctor here is absolutely right that nobody knows where to go, how to go, but they go to these unqualified people, and that is where the health hazard for women lies. So I think this needs to be strengthened, and that can be only done by the health ministry. And you have to man these centers, these community centers, and equip them with the facility, the doctor manpower, and the paramedicals in order to see that women get the right medical treatment. But I think it will take a long time till they fill up all these posts. They see that these centers run very, very effectively and efficiently to serve the women of this country.
And Dr. Malik also wanted to make a point. Ma'am, please go ahead.
So the other thing about the complications and the things is we have a provision of medication-induced abortions also, but which needs to be provided by the registered medical practitioner. But these drugs are freely available with the chemist. Anybody can go to the chemist and ask for the medicine. कि वो abortion करने की दवाई दे दो, और वो they just eat it, and then they have the problems of that. It may not be complete. It could be ectopic pregnancy also, like it's not in the uterus, outside, but nobody has checked her. So those complications are also occur. So that also needs to be looked into. That it should not be freely available. Those medicines that anybody can procure. That law is lax in our. Law is there, but it's not being applied. The laxity is there.
So that regulation is of paramount importance.
Exactly.
It's time to take some questions from our audience. Please go ahead, introduce yourself, and speak your mind.
Good afternoon, everyone. I think the amendment sure is empowering, but the benefits and services do not reach the people, specifically rape victims in rural areas. So my question is, how is the government planning on approaching this issue?
After the rape victim, she doesn't know after the incident whether she's pregnant or not. It's only after some time, maybe 20 weeks or maybe beyond that, she realizes that she's pregnant. And then that is where I think the counselor is required, somebody from an NGO is required, the family support is required, but the government has not made any provisions of this kind. I think even the government does not provide security or safety to the family or the rape victim. And that is where I think we need some kind of a safety net. This has been brought up time and again, and the government will have to look at this aspect. But it is definitely not happening. And as again, my colleague doctor said that, well, there has to be awareness and it has to reach the people in order to make them understand that you have rights and you can go to so-and-so places for help.
All right, next question.
Hello, my name is Nitika, and my question is that in rural areas, mostly rape victims do not know that they are pregnant until 20 weeks or 25 weeks. So what is the provision that we have for them? Because that is mentally very challenging to have a child that is born out of a rape case.
Dr. Malik, would you take that one?
Yeah, in fact, even if they have crossed 20 weeks earlier, we couldn't do any abortion, even if in a rape victim, beyond 20 weeks. Now, increasing the gestation from 20 to 24 weeks, and of course, beyond also in special cases. So it has been, once she knows about it, we can do the this medical termination of pregnancy. That's very much known. This new law has helped in that particular aspect. So that was there. So it can be done. And the other thing is about the education, sex education. That's important. They should know about their body, their how their, and that starts from the mothers and the schools. So that needs to be told to them about all these practices, so that she is aware of her rights.
So sex education is very important. Let's take another question now.
My name is Kirti and I'm from Miranda House. My question is regarding the social stigma that is inside the medical community itself. There are cases where patients are turned away from having abortions by doctors. So how do we curb that problem?
That's the question for your fraternity, Dr. Malik.
I don't think we are turning away the needy women as far as this MTP part, the abortion is concerned. It's not being done, and now as with the earlier, like we were very skeptical about that who was the partner, and now we don't need that information legally also. So that's very important, and now we are doing it. So otherwise, unmarried girls, no, they had to go to some private centers because officially we couldn't do in a government setup. That's, with this law, it's going to help all of you. That's important.
Absolutely. Time for the last question.
Hello, my question is to Dr. Yagnik. I'm Arshia, and my question is beyond 24 weeks, are abortions possible? And if they're not possible, can we make them possible in any way possible? Because rape cases happen, and sometimes financial issues also happen. So, because you're a women rights lawyer, do you think that we should take abortion cases beyond 24 weeks as well? Thank you.
Dr. Yagnik.
See, I think beyond 24 weeks is already now provided by the amending law. But you know what happens? Rape victims are practically going through such a trauma. I think you can imagine the trauma and the stigma and the nature of the crime is such that she is completely surrounded by continuous hounding. And in that particular situation, if she has to go for an abortion beyond 24 weeks, she would only worry about the well-being of herself, what health, what care she would get from the doctors, and whether she would like to bring this fetus into this world as a child, and whether the child will get acceptance. There's so many issues when I look at rape victims and I see the trauma, and I always feel that here is a life destroyed. She will never be the same again. Even if the child is born or the child is not born, she will never be normal once again. And that is the traumatic side. And so after 24 weeks, if the doctors say that it is medically possible and she should go for an abortion, I think most rape victims do not want that kind of a fetus. And they also worry about that the fetus might be abnormal. We do not know how that she will be able to act as a mother. There are so many emotional questions surrounding the victim. And I think this law is providing, the amending bill is providing for that provision. So women, rape victims, especially their young girls, they should be given this kind of healthcare help.
All right, so the amendment recognizes women's constitutional right to make reproductive choices, ensuring the right to privacy, dignity, and bodily autonomy. On that note, thank you so much for joining us, Dr. Yagnik and Dr. Malik. Next week, we'll return with incisive analysis of another important bill. Till then, take care and stay tuned to Sansad TV. Namaskar.